your interpretation is paramount, okay? And that gives, is a reflection, a clear indication of your sovereignty. You must understand that, because a lot of people fall into this trap when they walk into a court and a judge says, no, this is how it's read. Then you've just given up your sovereignty.
So if you answer back and say, but I interpret it to be...
You've got the backup of 2 High Court cases.
With respect, Your Honour,
I was taken to court for not voting, and I actually charged Julia Gillard. That was my grounds for not voting. When I mentioned that to the magistrate, he was quite keen to see why I didn't vote, my affidavit that I prepared. And I mentioned the treason charges. He says, that'll get you nowhere with me. I don't want to see that. Stop right there. He was quite forceful. If I had have known that, I would have said that straight at him. But it was dismissed anyway.
Well, it was brought up in a it was a county court recently. I was actually a magistrate's court. And the magistrate was shocked when this guy actually read out the 2 court cases that backed that up. And he adjourned the hearing. He walked out at 11:30. He didn't walk back into the courtroom until 2:30. And he was noticeably stressed. And eventually just dismissed the whole case, couldn't handle it. Okay? He could not rebut the claim out of those 2 High Court cases. Halford, the Commissioner, Department of Taxation, 1917, and Resch, the Department of Taxation, 1942. Now in 1955, we lost our High Court. That's when Menzies, who was a barrister, fought a case against the Communist Party, and he lost that case. The High Court ruled against what he wanted. He then, the next year, went into Parliament and he brought out a rule restricting access to the High Court. And that was when our High Court, we lost our High Court. And he then, basically, this was the first breakdown of the separation of powers. So that no longer did we have courts according to the Constitution. So we'll go to section 71.
We're going to have a bit of trouble with 71 because it's not very clear.
Well, first of all, we'll go to the heading, section 71.
It's not very clear, 71. I can't work it out.
Okay, what's it say there? It says chapter 3, and then what's the words after that? The judicature, not judiciary, the judicature.
What's the judicature?
That means that a court made up under the laws of England and the Magna Carta, which means that it is made up of judges, sovereign people, your peers.
Commonly called a jury.
Commonly known as a jury. Okay? That's what a judicature is. Okay? A judiciary is a court run by a judge or judges, guys with the dead sheep on their head. Okay, difference. So, section 71 says the judicial power and court, the judicial power of the Commonwealth shall be vested in a federal Supreme Court, also to be known as the High Court of Australia, not in such other and in such other federal courts as the Parliament creates, and in such other courts as it invests with federal jurisdiction. So, every court in Australia, state and Commonwealth, can exercise federal jurisdiction.
Well, section 5 that we looked at earlier says they must.
They must. When you request it.
Remember that link?
So what about the Judiciary Act, the early one? Is that,
1903.
is that contradictory to that, or was recent reprints of the Constitution changed that word to judiciary?
No, the word's never been changed. Okay, the Judiciary Act was brought in 1903, and the Judiciary Act was the first indication of some people who were part of those debates and who were installed in high positions within the judiciary did not like what they were confronted with. This particular section 80 of this section, chapter 3, which is trial by jury. Okay, they wanted the power to be within the government. And by 1927, they virtually eliminated the trial by jury in any other hearing other than a civil hearing, other than a criminal hearing. So all civil matters must be dealt with by judges or judiciary. And also summary jurisdiction came into being in 1920, and that just separated the whole system. And we had a total and absolute breakdown of our court system.
But I can't see infringements court.
That's right.
Like a computer.
Maybe it's the computer.
I knew it.
Unless you can get a computer, become a megabyte or something. Then.
So, Parliament cannot create a court outside of Section 71. Okay. So when you ask for a court to put itself into proper jurisdiction, then it's to fall within the parameters of the Judicature, Chapter 3 of the Constitution, and Section 71, and Section 80, trial by jury. So the trial on indictment of any offence. Okay, so indictment means presentment. Okay, so that's a summons. There's no distinction. There's no distinction. The courts will say there is.
Courts do say there is.
But
Indictment, they say, means a jailable offence. Indictment means go to jail. Indicted to jail.
The thing is, to confirm that there is no distinction between criminal and civil, we go to the Judiciary Act, and Section 80 of the Judiciary Act says common law to govern. And in that paragraph, it lays out in legal speak that there is no distinction between those two entities, civil or criminal.
Oh, it's been proven in the High Court just recently with the Hells Angels versus the New South Wales Government, where the judges said that he wasn't charged, put before a Chapter 3 court.
Yeah.
Remember what chapter the judicature was?
Yeah.
Chapter 3. Now, 1996, the High Court heard a case.
Chapter 3 judicature.
Was Cable, spelled with a K, versus New South Wales Department of Public Prosecutions, and in that case they found that the state courts weren't complying with Chapter 3, and as a result the Supreme Court ruling against Cable was struck out. And it's been repeated more than a dozen times since, right up until the 23rd of June this year. Okay, the High Court has continually said all courts must comply with this chapter. So we know they aren't, and in particular the Magistrates Court, so we fall on the Imperial Acts Application Act Victoria to find out what they actually are, and that is star changes. They were forbidden in 1640, so they do not exist. And that's under Section 8 of the Imperial Acts Application Act, which is habeas corpus. So, with respect to any fines,
Yeah, we should get back to that.
a fine can be brought about two ways. One, through a bill of exchange, okay, and that is with your consent. And that is, I don't want to go to court, okay, I'm guilty. Just give me a bill for it. And then it will be recorded against my name as I've committed a misdemeanour. There's a prescribed penalty. There's the money. See you later, Jack. Off you go. You get on with your life. Okay. Or a fine imposed by a jury, your peers. And they're the only two ways that fines can be applied. So that whenever any legislation says, oh no, well, I'm empowering this private corporation called Vic Roads or Traffic Camera Office or the Infringements Court to impose a fine, and you must pay it, or else then that is a perversion of the judicial power. It's perverting the judicial power. Now, the Attorney General of the Commonwealth a few months ago doubled the imprisonment term for anybody perverting the judicial power. Okay, now, a Star Chamber or any court that doesn't comply with Chapter 3 of the Constitution is a perversion of the judicial power.
Including Mr. Doyle and his police.
Yes. Now, the recent protests, in fact, Kelvin and I went to the protests on Saturday.
God, that's an experience.
That was,
You want to see some of them species in there
Yeah,
that
I saw last
pretend to
Monday.
be humans.
They come out of the zoo, I think.
God.
they did.
That's a
But
bit
the
cruel to
people
the zoo,
call-
don't you think? It's a bit cruel to the zoo, don't you think?
I think they get treated better in the zoo.
They may get a noise.
The core group, though, have a clear objective, and they see the problem with society and our enslavement to the corporations, and they want to bring about a change. And this was the aim of the original group at Wall Street, and it's, of course, it's spread to all around the world. But unfortunately,
Including down here in Gippsland.
yeah, they've
Gippsland too, was it? I knew they were doing them in Melbourne.
Yeah, well, the Melbourne group have been harassed by the police through the Lord Mayor of Melbourne, who has no constitutional validity, so he doesn't legally exist. So how can he possibly instruct the police force, who is another private group, to then take people off public land, sovereign people off
Yeah.
public land?
Yeah.
He's a square root of -1.
Yes.
Very well known.
Now, they were served a notice while we were there. I didn't cite the notice, but I had heard from people that come to our group in Ashburton that were there. They cited the notice, and there was no signature, there was no seal on that notice. It was just a piece of white paper with notice to get off this land.
They could have
It's of
just
no legal
ripped
effect.
it up,
Yeah,
thrown it away,
thrown it away.
and
But
stayed where they were.
the people that were there were in fear of it because they knew no better.
Yeah.
And this is the problem we've got. This is why it's so crucial that what we've got, the message that we've got in this group and the research that we're doing has to be common knowledge.
The same with when the ABS agents come and knock on your door and demand your blood and urine sample. You heard that news?
Huh?
And then they were told that it's not compulsory, but if you don't comply with it, then you'll be charged fines. And so people had to just invite them into their house and then answer all the questions that they asked and give them blood and
Send them to my place.
Oh, yeah, mine too.
Where's that?
I live in Maui. Send them to 42 Delatory Road, Maui on a weekend.
DNA sample. I think it was
So the-
America, I could be wrong.
Those of us that do
Demanding
know
DNA
this stuff, when
samples.
we put opposition to any invitation given by any of these unlawful entities, they very quickly turn around and go in the opposite direction.
I'm
They
waiting for
quickly
me
turn
smart
around.
meter.
We are putting the fear of God into a lot of these entities, judges, magistrates, all around the country, and police forces and the like. But what we urge more than anything is that the knowledge that you consume from this group and what we say must be used in a very humble manner and respect, regardless of whether it's a uniform in front of you. We must at all times maintain a ethical stance with respect to...
So you can't call the bloke in blue a maggot.
Yeah.